So the essence of reverse engineering and its relationship to the fair use doctrine is that, as I said before, right, copyright law doesn't protect ideas or facts. So if reverse engineering is required in order to gain some kind of access to the ideas or facts or functionality of a program, then any intermediary copies that are made as part of that understanding or part of that research on the original program are going to be fair use, okay? And there's a number of cases in this area, which I'll talk about in a little bit. But one of the main parts of the way that the case laws come out is that it shows that reverse engineering is not going to protect you from a copyright infringement claim unless you're legitimately in possession of the software that you're researching in the beginning, or if you use copyrighted code in your end product. Okay, they don't like that because the intermediary copies that you make to understand the program and maybe make whatever your new thing is going to be, those are fair use. But if you take pieces of the code and use it in your final product, then you're just copying, and the courts don't like that. Okay, so let me talk a little bit about the cases, and then if you still have your question. Okay, so one of the cases from 1992 is Sega versus Accolade. And, a lot of these reverse engineering fair use cases take place in the realm of gaming, a lot of gaming cases, and this is one of them. This is a Ninth Circuit case. The Ninth Circuit's our circuit here where we are, and also in California. Nice and big circuit, lots of law, and lots of video game companies and lots of internet companies. So persuasive on these kinds of issues because they see a lot of them. And in Sega, the court said reverse engineering is a fair use when there's no alternative means of gaining an understanding of the ideas and functional concepts in a piece of software. So it's okay to do this. And this case then led to Sony Computer versus Connectix. Now in this case, what was happening was Sony had a relationship between their player and the video games. And another company wanted to build an emulator that would play the video games on the computer, so you didn't need to buy the Sony box. Well, you can see why Sony wouldn't like this. They want you to buy the box and buy their video games because those two things go together. And we see this a lot, right? I mean, we see this kind of tying. This actually is a real interest of mine. We see this kind of tying between products all the time. And we see companies often trying to use various types of intellectual property law to get legal protection for a business model that ties the first thing you buy to aftermarket goods or services, right? So you buy your Hewlett-Packard server or whatever, and if you want to get it fixed, you've got to get Hewlett-Packard maintenance, right? And then you have all these third-party maintainers that were and servicers that were really big in the early 90s, and then Hewlett-Packard started putting in lockout codes and not giving those codes to the maintainers. And I've represented people. I represented a guy who was criminally prosecuted for having those lockout codes reverse engineered so that he could continue in his business of being a provider of upgrades and service to Hewlett-Packard servers. Not with a happy ending to that case, but I can talk about that more if people are interested. You can see it with like in the DMCA context, Lexmark sells their printers and they want you to buy the name brand Lexmark printer cartridges, and they have lockout codes that either make it impossible to put in a different printer cartridge or degrade the performance of if you use other printer cartridges. You have, meanwhile, the competitors who want to compete in the aftermarket services are reverse engineering these codes and trying to provide generic brand printer cartridges. Or in another area, which I have also been really involved in the cell phone area, you've got the cell phones, they're locked to a particular network, so they sell you the cell phone really cheap and they want you to then buy the service and keep buying the service from your particular provider, they lock the phone so that you can't then take that phone to another network, even though technologically the two should be compatible. And this case was no different. This was just an earlier version of this kind of tying arrangement. And what Sony said, hey, you're reverse engineering and then you're creating this emulator and you're violating our copyright in the code we use to run the PlayStation. It was a PlayStation then. So what the court said there was, they went through the fair use factors. It's sort of an really interesting kind of analysis, because if we go back, I'll just show you the fair use factors. The last factor here, the effect on the market or value of the copyrighted work, is the most important factor really in the fair use analysis. And it makes perfect sense if you think about it, because the idea of copyright law is that we want to assure to the creator the economic benefit of their creation in order to, incentivize them to make cool new stuff. That makes perfect sense. But the way the term is phrased, it doesn't really answer a lot of the difficult questions that you might have. One of them being, does the Sony emulator, or does the Connectix emulator interfere with the market for Sony products? Well, it might not interfere with the market for the Sony game products, but it definitely could interfere with the market for the PlayStation, because people will play the games on their computer instead of having to buy the PlayStation and play it there. And so, the question is that the kind of thing we're talking about? Is that the kind of profit protection we're talking about? Similarly, you could see how some kinds of reverse engineering or products, particularly if you're pointing out that a particular piece of software is insecure or vulnerable, could interfere with the market for that program, because now people know that it's not as good as they said it was and maybe they don't want to buy it. Is that the kind of interference with market that we're worried about? And what the court said in Sony versus Connectix is, no, that's not the kind of thing we're talking about. We're talking about people capitalizing on the creativity that goes into the copyrighted work, not interfering with any kind of like revenue stream or business model that the company may have come up with, okay? And that's really important. That's an important principle that I think, as the laws progress, to some extent, we're kind of losing track of. I think we're kind of developing towards a world where we think, hey, that's their business model, that's how they make money, they should be entitled to continue to make money that way. And we can talk a little bit more about that too. But regardless of this, you've got to be legitimately in possession of the software. So in Atari games versus Nintendo, in that case, the company that was doing the researching lied to the Copyright Office to get a copy of the source code. So they had lodged the source code with the Copyright Office to say, like, when they registered it, and the court said, and then the researcher said, we want it for this, and the court said, no. When you got it through that kind of subterfuge, you were infringing. There's another case, DSC, I don't have it on my list here. There's another case, DSC, Communications versus Pulsar. I forget the name, but basically this was about reverse engineering a kind of phone switch network for inside a company, and they basically used like some kind of shell third-party company to buy it, because the main company wasn't selling its product, restricted selling its product to any of its competitors, exactly because they didn't want the competitors to have access to it to reverse engineer it. Okay, this isn't so strange, right? Because when you buy software, there are some companies that sell software with end-user license agreements that say, you promise you're not going to use this software to compete with us, or you promise you're not going to use this software you're not going to reverse engineer it, you're not going to do benchmarking, you're not going to criticize it, you're not going to report on it, and we're trying to, basically you're attesting that you're buying it for purposes, to use it for purposes with which we agree. And we have some questions about the enforceability of these sorts of contracts, which we'll talk about a little bit later on. There have been some state attorney general's offices that have gone after this kind of project or process, this sort of protection that they're looking for. But, the status of the enforceability of these kinds of licensing agreements is still sort of up in the air. And, if you are a competitor, if you are a researcher, and the company doesn't want you to have access to the code, it makes your work a lot harder. You know, and I think that it's a issue that hits web researchers, people who do that kind of research, particularly hard because, you know, if you're, let's say you're doing research on a particular piece of code, you can buy the code and maybe the EULA is not enforceable, or you can get a copy of the code, you can buy the software from somebody else, you know, and then they delete their copy, maybe that's legal and you're okay. There's some ways you can get access to the code without having any kind of controls necessarily by the owner. But if you're researching, let's say, a particular implementation of something on a website or something of that nature, you know, not only does the website owner have, perhaps, maybe not, but copyright in the code, but they also have a lot of legal control over their boxes. It's their servers. They have control over those servers. And to a large extent, the law thinks that they have the rights to control the terms of access to those servers. So there'll be a terms of service or something like that, which will say you can access my website, but not for these purposes. So VeriSign had a terms of service that said you can search for who is data, but you can't search for it if you're a competitor. Or a site that had information for employees of Hawaiian Airlines had a terms of service that said you can search, you know, and log on here, but only if you're a laborer, you know, labor person in the Hawaiian Airlines management is not invited. Right, and then you have all these sorts of cases where these kinds of, you even have cases where there's no terms of service, where a guy who used to work at a travel company left that company, went to work for a new company, and helped the new company develop a way of spidering or crawling the original travel site to find out what they were charging for various cruises and vacations and stuff like that, so that they could set their prices competitively. And the court said, well, when he accessed his ex-employer's computer server for this competitive purpose that was contrary to the interests of the first travel site, that was also unauthorized access, because they would never have given him permission for that, and he probably knew that, you know, they wouldn't have given him permission for that. So, you know, this idea of permission and needing to have the permission of the copyright owner or the permission of the server owner in order to do the research that you want to do is a very serious and potentially limiting issue. Okay. Did you still have your question? And then I'll go to you.
So we talked about permission from, let's say, the software vendor. If they don't give you permission, but that's the interoperability of privacy testing, security testing, do they have to give you their permission even though it's an exception to the copyright law?
They don't have to give you permission. His question was, if, you know, because you're allowed to reverse engineer under copyright law, do they have to give you permission? And they don't have to give you permission. And the reason why is because of this nature of fair use, not as a right that you have, but as a defense to copyright infringement. So if you infringe, you can say, well, it was fair use. I was reverse engineering for fair use. That's what a defense means. If you had a right to reverse engineer or a right to fair use, then you would say, you're not allowed, you know, one of the implications of something being a right versus just a defense is I would say, I have a right to do it. You have to give me access because I'm entitled to do it. You guys see that difference? I didn't explain it well the first time, but it's seeing that difference between something being right or defense. Yes, sir?
Will you comment, please, on the difference between actually purchasing software and purchasing a license to use software?
So the question is about the difference between purchasing software and purchasing a license to use software. This is one of the great unanswered questions that's developing still in internet law that we're still kind of trying to grapple with. So the idea is that, you know, when